Today is October the 8th, 2014. It's a regular open meeting, and I'd like to ask Ms. Coleman to start with the Pledge of Allegiance.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of Mexico, the a symbol of perfect friendship among my united cultures.
All right, thank you. Item number 2, introductions. And item number 3, miscellaneous announcements.
Madam Chair, we have 2 items. I believe they're up there for signature. One is the employee of the quarter, and one is a certificate for Arthur Bishop.
Okay, Arthur's making his way in as a grand entry. Come on in, Arthur. Thank you very much, Arthur, for your service. You came from a charitable organization 2 years ago, I believe, and you definitely made a good transition to PRC, and now we're just celebrating your accomplishment as our public information officer. So
Thank you very much.
I would like to open this to the other commissioners if they would like to express an appreciation.
Madam Chair, I would.
Yes, Commissioner Montoya.
Arthur, you've been a valuable employee to the PRC, and we hate to see you leave. And we thank you for all your service.
Thank you very much. Appreciate it.
Madam Chair?
Yes.
Yes, Arthur, and I'd like to thank you for the last 2 years that I worked with you, for being very efficient, very transparent and open, and your articles were always very good. I'm going to miss you. I hope that you do well at UNM. I'll always be here to serve as a reference for you, should you ever need one, and I'm sorry to see another good employee leave.
Thank you. I appreciate it.
Come on up, get your certificate there, Arthur.
Okay.
Art, just work on your 3-point shot a little bit.
The certificate says, for outstanding and dedicated service to the citizens of the great state of New Mexico, thank you for your inspired and exceptional work at the New Mexico PRC. Congratulations and best wishes in your future endeavors.
There you go.
Okay. We have also, an employee of the quarter. The New Mexico Public Regulation Commission hereby recognizes Carolyn Glick as the New Mexico PRC Employee of the Quarter for July, August, and September 2014. Ms. Carolyn Glick serves as a hearing examiner with the Hearing Examiners Division. She has worked for the PRC for 7 years and 1 month. She was nominated due to her exceptional work on a number of high-profile, complicated, and difficult cases, including case number 13-00202-UT Jemez Mountain Electric Co-op. Ms. Glick's experience, professionalism, attention to detail, and judgment proved invaluable to the outcome of this case and to many other cases in her caseload. Today, we celebrate to present this Employee of the Quarter certificate to Ms. Glick. Thank you.
That's hard to tell.
Thank you.
Thank you. Good job. Thank you very much. You deserve it.
To me, you're not.
Carolyn, you've done a great job.
job.
Thank you.
Way to go, Karen.
Thanks.
Candace, you agree?
Madam Chair,
Yes, Vice Chair Espinosa.
we also had another good employee leave, and his name is Ruben Altamirano. He was an engineer out of Pipeline Safety, and his last day was last week, so we want to wish him well as well. Thank you.
Thank you. All right. Is there any other announcements? See none. Item number 4, consideration and approval of the agenda.
Move to approve?
I'd like to make one change.
Yes, Commissioner Lyons?
Yes, the last item on there on regular, discussion action 8A4.
Yes.
I'd like to take that off the agenda.
Okay, there's a motion and there's also a request to take off one case.
Second that motion.
There was a motion by Commissioner Vice Chair Espinosa. Is there a second?
Second.
Is there a second by Commissioner Lyons? All those in favor say aye.
Aye.
Aye. Opposed? None. Item number 5, consideration and approval of minutes of August the 27th, 2014 and September 24th, 2014.
Madam Chair, I move we approve the minutes as presented.
Second. There's a motion to approve and there's a second to approve the minutes of August the 27th and September the 24th. All those in favor say aye.
Aye.
Aye. Opposed? None. Okay, we have one consent action item.
Madam Chair, I move to approve.
Second.
There's a motion and there's a second to approve an action item. It's in the matter of an inquiry of line extension policies.
Madam Chair, there's actually 3 items, not one. One consent.
There's only one. Top of that says regular action, the very top.
Oh, okay.
Okay, there's one. All those in favor say aye.
Aye.
Opposed? None. Okay, now we are at item number 7. It's a utility matter, case number 14-00147-UT. Michael Smith is here to talk about this case. Michael?
Madam Chairman, Commissioners, this is, I put this on the regular action agenda, although it probably could have been on consent. This is just moving forward with the process that we have previously started with regard to an order to show cause against Mr. Romero and Mr. Serrano and their respective entities, the New Mexico Waterworks entities that operated that water system in the South Valley of Albuquerque, or Bernalillo County rather. This order would appoint Carolyn Glick, who's just before you, to conduct a hearing in this matter, proceeding in this matter to determine the respective liabilities of these two owners/operators of this water system under the Public Utility Act. There is, as you're aware, a receivership action in the Second Judicial District Court in which a receiver we're hoping soon will be appointed by the judge there to assume control of the water system and take over those operations. But in the meantime, staff's petition to determine the liabilities under the Public Utility Act should move forward. And that's basically what the order would provide for.
Madam Chair, I have a question.
Yes, Commissioner Lyons?
Michael, I noticed that we did send an order to show cause, apparently not received. Is that correct?
Yes, it was served on him by mail as the rules allow, but there was no return of receipt. So we decided that we should do, because, and as has turned out, Mr. Serrano has not responded to the order to show cause. So to have this proceeding move forward and the likelihood of a default entered against him, I felt it was better that we would go and serve actual personal service on him.
So did we send it to a physical address or a P.O. box or?
Off the top of my head, I believe it was to a physical address. I believe it was his home address.
All right, thank you, Madam Chair, that's all I have.
Thank you. Any other
Madam Chair,
questions? Commissioner Hall.
Thank you, Madam Chair. Michael, turn this over to the receiver. You know, in prior cases, when we turn something over to the receiver, at least somebody's got some money to pay the bills and whatever. This has been going on for at least 2 years with no money for anybody. Our attorneys have been trying to keep it afloat. Where's the money gonna come from for this receiver to take over? You got no, excuse me, let me finish. You got no water rights. Nobody wants to pay the electricity bill. Where's the money gonna come from? Are we just gonna inherit that thing? Go ahead.
Madam Chair, Commissioner, that's actually the reason that we're asking the court to appoint a receiver, is to have somebody, an objective third party under the court's supervision, to take control, make an assessment of the financial situation of the utility, determine whether the utility can be brought back up and running in a manner that they might be able to pay off those debts that currently are attached to this water system through rates to the customers, because nobody has charged these customers anything for years now. So there would probably be a case that would come back before the commission if the receiver believed that was the proper course of action, and we would have to approve rates. There's the possibility that the receiver could decide that this water system is unsalvageable. I requested the district court, in terms of appointing a receiver, in my view, that a bankruptcy attorney would be the best person to act as a receiver, somebody who has knowledge of those kind of procedures and whether that is really the only viable option, or whether it could be continued as an ongoing enterprise.
Madam Chair, Michael, in the past, to your knowledge of these, I think like 30 customers, have they been willing to pay a bill if it had been assessed to them, or do you know that?
That's really only hearsay that I've got. I know that there have been statements made that they've had trouble with the customers paying the bills, but the evidence we also have shows that there haven't been bills submitted to them in quite a while.
Thank you, Madam Chair. I wish the receiver luck.
Madam Chair.
Yes, Commissioner.
Michael Smith, I would encourage the hearing officer to look for an actual deed of sale or something that would prove, who bought it, who sold it, and who owned it. But, people aren't getting paid like the utility companies, and we can't go on much longer. And so, again, I would encourage the hearing officer to look for a deed of sale and see who actually owns it, who's been contributing, and hopefully the 31 users of that water system won't get stuck paying for all the bills that will follow it with the receiver.
Madam Chair, Commissioner, that's what we hope the hearing examiner will be able to do, rather that will be part of their tasks in unraveling the liability. I know there was a sales transaction of the utility from one owner to the next, and there are a lot of issues, factual issues related to that need to be established.
And the hearing officer should also look at the environmental part of it. Is it safe drinking? There's a lot of problems that could follow. Again, and then the 31 consumers get stuck paying for all of it at the end of the day.
Madam Chair, Commissioner, I just wanted to assure you that's part of the reason that we wanted to get it in the hands of a receiver who would operate it, is to work with the Environment Department on the outstanding environmental issues that are related to this.
Or maybe
as well.
investigated the city lines from the water become part of the city. Anyhow, thank you.
Any other questions? Michael, my question is, this is a pending case in the Second Judicial District Court. At the same time, we're appointing a hearing examiner. Can you explain why those two actions are occurring?
Madam Chair, they're two separate issues. One is we have jurisdiction over violations of the Public Utility Act, and as the owners and operators of this public utility, we have primary jurisdiction over issuing fines against them, at this point, because there's a receivership in place, it's not really realistic that we would bring them back into compliance, but there are certainly enforcement issues that are raised by how this utility has been handled, which is a kind term, I guess, in the past. And the receivership action, this commission, in the initial case 12289, we held a public hearing and determined that appointing a receiver would be the best option. It's basically take it out of the hands of these two owner-operators who have not been able to operate it in compliance with other law, and have somebody responsible operate the water utility. The law requires us to go to the district court to initiate a receivership action. So our action here was just a vote to go and start the court case there to put the receiver in place. But we still retain our jurisdiction over the issues related to the Public Utility Act. And so a receiver would actually still have to come back to us, to the PRC, for approval of the various actions that he would take acting in the place of the owner or operator of the water system.
There was also an order that was approved by the commission, an order to show cause, and he didn't respond. How do you expect the hearing examiner to obtain more information if he's not responding?
Madam Chair, we basically, because we're not adjudicating a private party's rights at this point, a default judgment against him really doesn't serve the purposes that we need served, which is establishing who is responsible to the utility, to the PRC for what's taken place. The hearing examiner will do as much as she's capable of doing without the cooperation of Mr. Serrano and his corporate entity. We intend to serve him with additional notices of any hearings that may take place under Ms. Glick's supervision, so that at the end of this process, due process has been complied with, and he has been provided every opportunity to participate in the court proceedings. Ultimately, if he's given that opportunity and he fails to participate, then if there is a decision adverse to him adopted or entered by this agency, he basically will have to live with those findings, because we will have followed the law to the best extent we can in terms of having him actually participate.
Thank you, Mr. Stein. Any other questions? What would the commissioners
Madam
like?
Chair, I move we approve the order
Okay.
appointing a hearing examiner.
Second that.
There's a motion and there's a second to approve the order presented by Mr. Smith. All those in favor say aye.
Aye.
Aye. Opposed? None. Okay, we go to the next action item. It's Judith Amer's case. It's in the matter of the adoption of a proposed rule to implement the Efficient Use of Energy Act. We also have Mark Martinez here. Good morning.
Good morning, Madam Chair, members of the Commission. This proposed Rule 17.7.2 comes before you to implement the legislative changes made to the Efficient Use of Energy Act, 62-7-1 et sec, which I will refer to as the Act. In 2013, House Bill 267 was passed by the legislature, and it became law on July 1st, 2013. I will provide you with a brief synopsis of the changes made to the Act by House Bill 267, which are very important parts of this proposed rule. House Bill 267, very importantly, capped and set a floor for the funding for program costs at 3% of customers' bill, excluding gross receipts tax, franchise, and right-of-way access fees, or $75,000 per plan year per customer, whichever is less. The $75,000 per customer per calendar year cap is no longer the cap for electric utilities. Program costs for gas utilities is worded differently, such that funding is up to 3% of annual revenue, and charges shall not exceed $75,000 per natural gas customer per calendar year. Also important, House Bill 267 replaced the definition for the test for cost effectiveness from total resource cost test to the utility cost test, which compares the monetary cost borne by the utility versus the avoided monetary cost of acquiring supply-side resources. House Bill 267 added a definition for the term program costs, which are the prudent and reasonable costs for developing and implementing energy efficiency and load management programs. Program costs do not include charges for incentives or the removal of regulatory disincentives. House Bill 267 also no longer requires that all energy efficiency resources be cost-effective, only that the total portfolio of programs be cost-effective. House Bill 267 reduced each electric utility's savings requirement from a minimum of 10% to a minimum of 8% of 2005 total retail kilowatt hour sales to the New Mexico customers in calendar year 2020. And the Commission is allowed to lower the savings requirement if it determines that the program costs to achieve these minimum requirements would exceed those established by the cost recovery section of the Act. And finally, House Bill 267 required that a minimum of 5% of the funding received by the public utility for program costs be directed to energy efficiency programs for low-income customers. In addition to incorporating House Bill 267's changes, the proposed rule before you sets the energy efficiency funding at 3% and keeps the $75,000 cap for large electric utility customers. Adds some definitions to the established Act definitions, staggers filing deadlines for annual applications and annual reports, spells out the application requirements, including the 3% cap, program funding requirements, and how to apply for incentives. The rule requires that utilities report how they met their pre-filing requirements, including a description of the process used to solicit non-binding recommendations from third parties. The rule requires that utilities estimate plan year revenue numbers as the way to determine plan year costs, and requires them to use their best efforts to spend all of their allocated funding on cost-effective energy efficient programs and measures. The rule provides a method to adjust prospective program funding to reconcile underages and overages, as well as adding definitions for these terms. It allows utilities to seek an incentive award and specifies that this incentive be based on the utility's cost, the utility's previous performance, testimony and documentation and support, and it provides a cap to the incentive, which is detailed as not to exceed the product of its weighted cost of capital and its approved program costs. The rule states for residential programs that no less than 5% of the amount received by the public utility for program costs shall be specifically directed for low-income customers. It sets forth the filing requirements for cost recovery and recovery of regulatory disincentives. It sets forth a process to select an independent program evaluator related to the measurement and verification requirements, and requires the utility to initially pay the program evaluator and subsequently collect the cost for that payment from its ratepayers. I will now briefly summarize the procedural history of this rulemaking. On September 23rd, 2013, staff filed a petition to initiate rulemaking that requested the Commission enter an order repealing and replacing the existing Rule 17.7.2 NMAC and removing the existing rule from state records. they attached a proposed rule, which I will at times refer to as the NOPR rule. On October 3rd, 2013, the Commission issued its order to initiate rulemaking. On October 12th, 2013, the notice of proposed rulemaking provided notice that a public hearing would be held on November 20th, 2013. Prior to the public hearing, the following individuals and entities had filed written comments. P&M, the Attorney General, New Mexico Utility Share Alliance, James Crawford of Los Lunas, New Mexico Industrial Energy Consumers, El Paso Electric Company, the Coalition for Clean Energy and Western Resource Advocates, known as CCAE/WRA, Southwestern Public Service Company, and New Mexico Gas Company. The public hearing was conducted on November 20th. 4 individuals who did not file the written comments. At this point, I will now just briefly go over some significant issues that were raised by the commenters and summarize the Office of General Counsel's recommendation on whether or not to change the rule as proposed by the NOPR. The first issue is what is the appropriate timing for the submittal of applications and reports. The answer that OGC recommends is keep the proposed rules annual application and reporting. As stated before, the proposed rule calls for annual applications. Many parties suggested applications be made every other year. After reviewing the comments, OGC recommends keeping the annual applications. OGC believes this facilitates the reconciliation of funding overages and funding underages. That's a process that occurs annually that determines whether a public utility has spent more than its 3% or less than its 3% of allocated funding. The Office of General Counsel also believes that reports should be filed annually. And finally, the rule proposes staggered filings to alleviate a logjam of filings that might occur if all the public utilities had to file, let's say, on February 1st. Or so the way the NOPR rule states that P&M will file on March 15th, SPS on May 1st, and EPE on July 1st. Another issue was what criteria are appropriate for granting an application for an annual incentive award. OGC recommends maintaining the proposed NOPR rules method of determining how to get an annual incentive award. P&M proposed an entire rewriting of this section. They requested that the application include a proposal for an opportunity to earn a profit on energy efficiency programs that, with satisfactory performance, is financially more attractive to the utility than supply-side utility resources, such as lost profits, avoided costs, shared savings, or return above program costs. P&M stated that the utility should show that the amount of the profit opportunity requested is financially more attractive to the utility than supply-side resources without being excessive. And P&M wanted to recover the amount of taxes due to the proposed profit opportunity. In contrast, the AG commented that because the utility is not placing any of its own equity at risk in developing the energy efficiency programs, as would be the case with traditional supply-side resource development, the AG believed that the annual incentive award should be lower than the proposed rules cap. Finally, staff disagreed with P&M's rewrite of the rule and also agreed with the AG that the annual incentive award should not include tax. After weighing all the comments, OGC's recommendation is to keep the proposed rules balanced language and not to include tax in the annual incentive award. OGC recommends that the Commission not include the specifics mentioned by P&M. we note that this is a very complex issue, and it's not necessary for the commission to decide it at this time. More time would be required to appropriately address this issue. But the need for time conflicts with the need for the commission to issue a final rule in this particular matter because the law was changed on July 1st, 2013. Importantly, OGC's recommendation to keep the rule unchanged does not foreclose any party from including any information that it deems or chooses to address when it applies for an incentive award. Another important issue that was commented on is what's the appropriate criteria for granting the removal of regulatory disincentives. Similar to the request for annual incentives, P&M proposed an entire rewrite of this section. NMEIC and CCAE-WRA did not approve of P&M's rewrite. Both groups wanted to keep this section of the rule more generic and less specific. After weighing all the comments, OGC recommends keeping the proposed rule, section 17, basically unchanged and leaving it more generic. We do not recommend that the commission decide at this time this contested issue. And similar to the annual incentive award, our recommendation does not foreclose the presentation of any information any party chooses to add when they apply for the removal of a regulatory disincentive. Another issue that was commented on was changing the measurement and verification procedure for choosing an independent evaluator. The proposed rule in the measurement and verification section 15 provides that the utilities' energy efficiency programs shall be evaluated at least once every 3 years by an independent evaluator that's recommended by staff, resulting from the RFP process. Staff administers the contract without input from the utilities. The independent program evaluator will be paid initially by the public utility, and such payment is to be treated as a regulatory asset and recovered from ratepayers through rates established at the next general rate proceeding. Staff requested that in consideration of P&M's comments, this section should be revised to allow consultation with the utilities for the selection of the independent evaluator. After reviewing all the comments, OGC recommends adopting staff's change to allow consultation with utilities for the selection of the independent evaluator. Staff's RFP and contract duties would remain, so that staff, the role would read, staff to fulfill its obligation under selection of an independent program evaluator may consult with public utilities and other interested parties. Staff shall undertake the competitive bid process, shall develop a request for proposals, receive, review, score, and rank RFP responses, negotiate the contract, and administer the contract. Many people commented that the objective section of the rule needed to be rewritten. Staff, CCAE, WRA, and EPE all preferred the existing rules objective section. They also commented that the Act does not require that all programs be cost effective, only that the portfolio programs be cost effective. As a result of these comments, OGC recommends adding the phrase portfolio programs, since that phrase is consistent with the Act's language. OGC also recommends deleting the phrase by which the public utilities and distribution cooperative utilities, so that the final rule is a more accurate statement of the rule's purpose. It's in your packet, I can read it to you, but the objective section is reworded And at this point, OGC recommends that it's a better statement. It's interesting that the definitions section were also had many comments. For example, the definition of the word estimate or estimating. PNM, CCAE/WRA, and NMPRC all said that a definition of estimate was not necessary and wanted this definition entirely deleted. OGC recommends against the deletion of the definition of estimate because this word is important throughout the entire proposed rule and is used frequently. It is critical to the energy efficiency program that when a utility makes an estimate, it needs to be more than just an approximate guess. However, in consideration of staff's comments, OGC does recommend revising the word as follows. So that estimate would read, a projection or forecast utilizing well-known, commercially available, or standard engineering, economic, and financial calculations, ratings, and simulations, or other reasonable means. OGC recommends deleting language that said with a high degree of certainty or a reasonable proposed standard deviation on balance, we believe that OGC's recommended rewrite is a better definition. Life cycle basis was also a word that had many comments. Staff wanted the word basis deleted. However, in the Act, the definition of utility cost test specifically uses the term life cycle basis. So OGC recommends not deleting the word basis. Staff and PNM wanted to delete the phrase regarding annual traditional revenue requirements approach. OGC does recommend deleting that phrase. Low-income customer. Many commenters, including staff, PNM, DAG, CCAE/WRA, all requested that the term low-income customer be raised to 200% of poverty level. As you may recall, the existing rule has 200%. The NOPRD rule went down to 150%. OGC recommends going back to the 200% of federal poverty level. That will allow more people to be considered a low-income customer. The definition, measure, or program also had comments. Staff recommended deleting the word measure and wanted to delete the definition of measure or program. PNM and CCAE also wanted the deletion of the word measure. On balance, OGC recommends keeping the word measure because the Act itself repeatedly uses the word measure and uses the phrase measure or program throughout the Act. The definition of measurement and verification also had comments. Commenters wanted to delete a high degree of certainty. OGC agreed with the commenters and did delete the phrase high degree of certainty and changed it to a cross-reference to the definition of estimate, which I've already detailed. Planned year was another word that had comments. At first, OGC had thought that the appropriate definition was to include the word period after the word calendar, so that a plan year would be a calendar period. But in consideration of staff's request, and because the utility's financial data is compiled and reported on a calendar basis, OGC now recommends that a plan year be defined as a calendar year, January 1 to December 31st. OGC also recommends keeping the proposed rules staggered annual applications for the reasons I previously detailed. And finally, The Attorney General wanted two definitions added for plan year overage and plan year underage. I've already described what they mean. We included them as actual definitions, and then instead of having the definition embedded in the rule, we just use the term plan year overage and plan year underage. So on the whole, based on the foregoing, I recommend that the Commission adopt and approve the final order repealing and replacing Rule 17.7.2 and approve the final rule, which I attached as exhibits A1 and A2, a red line and a clean version to the final order. The red line version has the OGC's recommended changes to the note rule, and then the clean version is the way the rule will look when it's published at State Records and Archives. And I stand for questions.
Thank you, Ms. Amer. Very thorough, very good job. Thank you. Questions from commissioners? Commissioner Lyons?
Thank you. Judith, first off, you really dove into this and got a good understanding of energy efficiency statute and the rulemaking here. You really did a great job. And Mike, thanks for getting it on the schedule, get it done this year. This is something I've been working on since I first got here about 4 years ago. I knew there was going to be a lot of problems with the energy efficiency because there wasn't any cap at 3%. It was just going up and up. And after we took off the low-hanging fruit of changing more efficient light bulbs and energy demand response, and little things do like that, if it's getting harder and harder to get that energy efficiency and the taxation of the bill has kept going up and up and up, and it's going to be at 6 to 8 to 10%. So I was one of the pretty people that went to the legislature and got House Bill 267 passed with a 3% cap. And I think what you guys have put together here is a good balance. The regulation goes along with the statute of the law that we passed here, because one thing we worked on there was the 5% to the low income benefits, and that was put in there, and I'm so glad we got in there. Also, I think the annual adjustments true up is better than just a biannual, because you know what's happening that year, what programs are working and not working, because a lot of these companies are just throwing out programs trying to meet it, and they weren't working, so we'll know that in a year's time. And there's several things in here I really like. I think it'll benefit the customers, and also we all want to try to get more energy efficiency. At the same time, it limits what it's going to cost the customer and get the maximum benefits. And with that, I'll give up the floor and let someone else talk.
Great. Thank you, Commissioner Lyons. Any other questions, comments?
Madam Chair.
Commissioner Hall?
Thank you, Madam Chair. You know, this rule has been kicked around since way back 2005, 2007, somewhere around there. Been tried to be revised over the years. Commissioner Lyons and I have been there 4 years. We started talking about this thing 4 years ago. There was attempts made to add things into like the decoupling and everything along the line somewhere, which got batted down, I'll put it that way. But this, I believe what you've come up with here in this new revision is what will work for a while. And Commissioner Lyons and I advocated a long time ago. The first right of the 17-7-2, they got in too big a hurry. So they missed a lot of things. That's the reason the Supreme Court vacated a lot of it. And like I said, since then, attempts have been made to revive the rule. It's never been successful. I hope this one gets on the books, and I believe it'll make a great contribution to the people of New Mexico. Thank you very much.
Madam Chair?
Yes.
I just want to thank you both for your efforts. This makes for a much better product, a much better process. Also, it starts tracking the issues where they didn't track before, and so you did an exceptional job of making it a win-win for both sides. Thank you.
Thank you. Commissioner Montoya.
Madam Chair, the energy efficiency program is a great program from New Mexico, as we know, and I hope we continue to find the maximum benefits, the best uses that we can for these programs, so that the people of New Mexico can benefit in big ways. Thank you, Madam Chair.
Thank you. One question that I have, Ms. Amer, is public education for all ratepayers. Was that brought up during the process?
Yes, from the former rule had a section on indirect impact costs. And in the proposed rule, that section was not included. It's something that is encouraged, but it's not something that is part of the application process. And I know that P&M asked that it be inserted back in.
I think that's something that we would like to see perhaps the next time that we modify the rule. That's just my take on it. Mark Martinez, do you have anything to add?
Madam Chair, Commissioners, I do not have anything yet. I thought Julie gave an excellent explanation.
Right. Ms. Amer, do you have anything else to?
No,
Okay.
nothing else to add.
Okay, great.
With that, I'll make a motion to approve the order as is.
Second that motion, please.
There's a motion to approve the order and a second to adopt the order presented by Ms. Amer. All those in favor say aye.
Aye.
Aye. Opposed? None. Okay.
Thank you.
Thank you. Good job.
Thanks for a lot of hard work.
Okay, item number 9 is a closed session, and is there a motion to go to
Oh,
closed
wait, Madam
session?
Chair, I do have something that I need to announce. There's a gentleman in the audience by the name of Stephen Asher with Cooling. I could see him gesturing in the audience that he could not hear, so I asked him, how we can help him. But I think he doesn't understand. He's here with Cooling, so I don't think he understands that it has been tabled. So I've asked Sandra to please explain that it's been tabled. If he chooses to stay and listen in on the meeting, maybe we can all just speak a little louder and clearer so that he can understand. But I know he's here for Q-Link, and that's been tabled. Thank you, Sandra. Thank you, sir.
Thank you, Madam Commissioner.
Thank you. Item number 9, closed session. What is the wish of the commissioners? Would you like to go into closed session? Item number 9, the commissioners want to go into closed session.
I want to thank Mike for putting it down here, really spelling out exactly what we're going to talk about in this special session. That's what closed session, we know exactly what we're going to do here now, and the public knows what we're going to do. You have five or six lines there that tells that. So with that, I'll make the motion to go to closed session and talk about the court case number, I guess 34220.
Okay, there's a motion. Is there a second?
I'll second.
And second by Commissioner Montoya. Roll
Commissioner
call,
Montoya, how do you vote?
Yes.
Commissioner Hall,
Yes.
Commissioner Vicente Aguilar,
please. Yes.
Commissioner Espinosa.
Yes, and I just want to mention that last week, Michael Smith also listed a very detailed list of actions that we were going to discuss in executive session.
Thank you, Commissioner Lyons.
Yes.
It is unanimous.
Okay. Ladies and gentlemen, we'll have to go into closed executive session, so I'm not sure how long it will take, but if you can just please come back for the remainder part of the agenda.
And Dennis, we're here.